Good evening, and welcome to the new listing for Social Security. This webinar and tele-learning series is brought to you by CanDo Multiple Sclerosis, the National Multiple Sclerosis Society, and the Multiple Sclerosis Society of Canada. My name is Laura Coyne, and I'm the Programs Manager for CanDo MS. I will be your moderator for the evening. CanDo MS transforms lives. We deliver educational programs on exercise, nutrition, and symptom management to inspire and motivate long-lasting change for those with MS and their families to help them thrive. Please visit the CanDo MS website, mscando.org, to learn more about CanDo MS's online and nationwide in-person programs. CanDo MS is excited to partner with the National MS Society to bring you 16 webinars in 2017. The mission of the National MS Society is to help people affected by MS live their best lives as they stop MS in its tracks, restore what has been lost, and end MS forever. You can explore other societies' programs, services, resources, and connection opportunities at nationalmssociety.org. Our speakers this evening are Jamie Hall and Roz Cab. Jamie Hall is the owner and founder of the Law Office of Jamie R. Hall. His areas of concentration are in Social Security disability, long-term disability, unemployment, and workers' compensation claims. Roz Cab is a clinical psychologist who has specialized in MS care, support, and education for over 30 years. Roz joined the National MS Society in 2000, creating online resources and educational materials for individuals and families living with MS and healthcare professionals until 2017. She continues her resource development work with the Society as a consultant. And with that, I'm now going to turn the meeting over to Roz Cab.
Hi, everyone. I'm very excited to be here with my colleague Jamie tonight to share some important information about the Social Security Administration, or SSA as we call it, Social Security Disability Criteria and Application Process. Applying for these benefits has never been a simple or easy process, and recently the SSA has made some significant changes. In fact, the first changes since 1985. And these changes, which reflect the feedback that SSA received over the past several decades, introduce some new opportunities as well as some challenges for people with MS. The good news is that these changes take into account the variability and invisibility of many MS symptoms and offer ample opportunities for people with MS and their healthcare providers to demonstrate MS impairments that interfere with a person's ability to work. Now, before I hand this over to Jamie to explain how a person qualifies for disability with these recent changes, let's do our first polling question. How many of you have applied for disability? Please select one. Interesting distribution. So about half of you have not applied. So you're going to be getting valuable information tonight about what that process is like. And 22% of you have already been approved. And our fingers are crossed for the 16% of you who have a current application in process. So thank you for that. And now, Jamie, I'm going to turn it over to you.
Yeah. Thank you much, Roz. I appreciate that. And to those of you who have been approved for disability, congratulations. Those of you who are applying or looking to apply, I wish you the best of luck going forward. And I hope we can help make the process a bit more easy and less confusing for you moving forward. Initially, a brief disclaimer. We're going to talk quite a bit about the Social Security Disability Program today. What we discussed today is not a replacement for individualized legal assistance, but more of a general overview of how the process works and general ideas on how to best use the process as you move forward. Additionally, there's a few acronyms we'll use during the course of the presentation. Three of the primary ones are SSA for Social Security Administration, SSDI for Social Security Disability Insurance, and SSI for Supplemental Security Income. Primarily, we'll talk about Social Security Disability Insurance, which is the kind of disability out there by the federal government for people who have a strong work history in their past and a recent work history as well. For SSDI benefits, there are essentially two basic requirements for the initial application. One is that Social Security will only consider a sufficient disabling condition, and that includes any condition that will last at least 12 months or is anticipated to result in someone's passing. For instance, MS would obviously be a condition they consider, as would diabetes, as would many other conditions. They have this limitation so they don't consider other more short-term issues, a broken leg that heals properly, a pregnancy, items of that nature. So the only conditions the SSA will consider are conditions lasting 12 months or that will end in death eventually. The SSA also requires that a person have sufficient work history to qualify for SSDI, and that includes both lifetime work and recent work. It's important to understand that these thresholds are relatively low. A person who has stayed in school for a long period of time to obtain an advanced degree, has taken time off of work to raise children or something like that, as long as absent those periods they have worked regularly, they'll typically qualify for the lifetime work period. Similarly, recent work includes work for 5 of the previous 10 years before the disability began. So again, they're looking at generally work over your lifetime and work that's done recently, at least 5 of the previous 10 years. It's also helpful to know that when they talk about work, they're not always talking about high-level income or high levels of work in general. A full year's worth of work is somewhere in the range of $6,000 of income. So even a person working part-time may be able to qualify with the lifetime and recent work standards. We'll also touch on SSI during the course of the day today. And it's well worth knowing that SSI has the exact same medical requirements as SSDI. So as you hear us discuss the different medical requirements for disability, there's no difference between those two programs. The primary difference between the two programs is that SSDI is a program that typically pays a higher benefit, does permit some part-time work, but that requires a work history, as talked about a moment ago. SSI, conversely, does not require a work history, but pays a lower benefit and also has significant restrictions on whether any kind of part-time work or income is permitted. The next slide, please. So the first test I want to talk about today is what I call the two-step test for SSDI. And this test applies to any condition out there, whether it's MS or an orthopedic injury, whatever it may be. And this test has not changed under the recent Social Security guidance. The initial test they look at for SSDI, this two-step test, includes, as you may have suspected, 2 steps. Initially, the SSA will ask if a claimant can perform the work they've done in the past 15 years. So work that presumably is relatively fresh on your resume, and you'll be able to jump right back into. If you show you can't do the work you've done in the past 15 years, Social Security moves on to a second part of that test and asks whether you can do age-based fictional work. And that fictional work is based upon how old you are. For individuals under age 50, the SSA will ask, can you do the work you've done in the past 15 years? And if you can't, they will then ask, can you do sedentary work in any kind of position? If you're over age 50, Social Security will ask if you can do the work you've done in the past 15 years. And if you can't do that, they'll ask if you can do light duty work. It's important to know that sedentary work is sit-down work, secretarial position, ticket taker at a movie theater, some video surveillance positions, things of that nature. Light duty work is work on your feet, such as a cashier, an assembly line worker, something on your feet throughout most of the day. These fictional jobs we talk about, and frankly all jobs we discuss in a disability claim, are full-time positions, anticipated at 8 hours per day, 5 days per week. So the ability to do a job part-time, perhaps in the morning before fatigue sets in, or only on good days when you're feeling well, is not truly relevant. The SSA will consider only your ability to do full-time employment 8 hours a day, 5 days a week. Now, in the event you're able to show that you're not able to do your prior full-time work in the past 15 years, or this age-based work, the guidelines out there would suggest an approval of disability as appropriate, regardless of your condition. To make that determination, there are several factors the SSA will look at. I can get the next slide, please. These factors include, for an MS patient, first and foremost, fatigue. As we mentioned a moment ago, doing the job 8 hours a day, 5 days a week reliably is a major factor the SSA will consider. And it includes either physical or mental fatigue. If you have to take breaks throughout the day, or if you have to take an afternoon nap to cope, despite taking medication, despite watching your activities, fatigue alone may be a factor supporting disability. Generally speaking, the SSA permits no more than 6 minutes per hour off task. So if you're taking rest breaks more than 6 minutes per hour, fatigue may give rise to a valid claim. They also consider good days and bad days. If you're having days with your MS when there's exacerbations, or simply fatigue or physical inactivity is greater, that may in and of itself support a claim as well. The SSA typically allows a person somewhere around 3 days per month out of work, and at that point, a person is not employable. For instance, if you picture a person applying for a job at, say, Walmart, and if they're a wonderful applicant, but they tell the employer on day one, I'm going to miss 3 days a month at random due to my condition, their employability would be dramatically reduced. So the SSA looks at good days and bad days, and if you're unable to work approximately 3 days per month, you're not able to work in the competitive economy. The SSA also looks at upper extremity limitations. Do you have hand numbness and grasping issues that would prevent you from doing many jobs? They look at bladder issues, frequency of restroom use. We mentioned breaks a moment ago. The same breaks apply here. If you have to go to the restroom hourly and you're maybe not moving quickly to get there, that may give rise to breaks that are above and beyond what are permitted in the economy. Similarly, cognitive slowing may prevent you from maintaining the pace required by Social Security. And finally, lower extremity limitations are of great value, but primarily to a certain age group. Many of my clients who call in will note that they have these issues with walking and standing for extended periods. As you may recall, the factors for a disability claim under this generic two-step test, if you're under age 50, includes sit-down work. So lower extremity issues wouldn't be as relevant in this type of claim. However, if you're over age 50, the standard typically requires that you be able to stand up at work. And in that kind of scenario, these lower extremity issues are incredibly important because it would prevent a person from standing throughout the workday. Next slide, please. So we just talked a moment ago about the generic standard for disability that applies to all conditions. Due to efforts of many of the MS-oriented groups, including the MS Society, there is an additional listing out there for multiple sclerosis. And a listing is a second and additional test to possibly get a person approved for disability. So Social Security will ask everyone the question we talked about a moment ago, but they will also ask MS patients specifically these additional questions. And if you pass under either set of questions, you'd be approved for disability. You don't need to qualify under both sets. The listing for MS is listing 11.09 under the Social Security listings. It is notable that these listings were revised in fall 2016. So if you do any kind of online research or anything like that, you have to make sure the data you're looking at is developed as of fall of 2016 or more recent. It also means that attorneys and judges are still figuring out how to apply this new listing. We believe we have a good handle on it, but it's only been approximately a year we've applied it, so we're still working on it and figuring out how to best apply it to the unique conditions of MS for every claimant. Now, the MS listing itself has two separate listing tests, one based on extreme limitations, one based upon marked limitations. And you don't have to show both of the tests. You only have to pass under one of the tests here, either showing you have extreme limitations as required or marked limitations as required. And let's talk about those tests now. The first test we'll look at specifically for MS patients is the extreme limit test, and that's under 11.09a. And this test is actually similar to a listing that existed previously. It focuses on disorganization of motor function in two extremities. In simplistic terms, two of your limbs don't work as they should. Either an arm and a leg, two arms, two legs, whatever combination it may be. And that disorganization has to result in an extreme limitation of your function. Specific examples that the SSA is given of what this extreme limitation may include an inability to stand from a seated position. You lack the strength and dexterity in your arms to push yourself up, and/or in your legs to stand once you get there. They focus on your ability to stand or walk and maintain balance. For instance, picture a person with a walker in a parking lot, and you take that person's walker away. Could they maintain standing unsupported? Would they have the leg strength and the leg endurance and the balance to maintain that kind of position? Could they walk and get to a place where they could sit without assistance? They also look at use of upper extremities. And many MS patients have more dramatic issues in the legs than the arms, but this would focus on a lack of ability to type, to properly grasp, ongoing and extreme numbness of the upper extremities. And remember, the word they use here is extreme, not limited difficulty, not some problems sometimes, but extreme. It should really be preventing many daily activities, either by issues with the legs or issues with the arms or a combination of the two. This is, in my experience, a very challenging standard to show you have this kind of extreme issue with two extremities. However, if you can't show extreme limits, you may be able to show marked limitations. And if I could get the next slide, please. So if you can't show that you have extreme limitations, you can pursue approval under marked limitations under what we call listing 11.09b. And marked limitations will focus on two things. They'll focus first on your physical function. And the SSA has defined it with that long sentence noted there: persistent or intermittent symptoms that affect your abilities to independently initiate, sustain, and complete work-related activities. And these work-related activities may include standing, balancing, walking, or using two extremities to type, sort, handle. What we note on here, and an angle that we've taken in recent cases, at least in my office, is that persistent or intermittent symptoms and the independently sustain activities. We look to that and say that that is a strong indicator that fatigue may support marked limitations in physical function, and that you may be able to stand or walk or function for a period of time, but over the course of a workday, you're unable to maintain that pace. And again, if you picture a person working as a cashier, many MS patients we find can do that job for an hour or two, or maybe a morning, but to come back and complete the shift in the afternoon, or come back the following day or complete the work week, that is part of the issue with sustaining work-related activities. So we find that this does give strong view to fatigue and fatigue-based issues. Marked limitations are something less than extreme limitations talked about a moment ago, and again, that persistently or intermittently impact your ability to do work-related activities. If you show those kinds of issues with physical function, you also have to show issues with your cognitive function. And that's the difficult part about this listing, is it's not just physical. This part of the listing requires marked issues with physical and cognitive function. If I can get the next slide, please. When the SSA looks at cognitive function, they've given us 4 individual areas of thought to focus on. First is concentrating, persisting, or maintaining pace. For instance, is your thought process good enough, and do you have the mental endurance to maintain pace without unscheduled breaks? Many of my clients can do things for a short period of time, but even watching a television show requires breaks, or reading a book requires them to take time off frequently to maintain that task. If you're taking unscheduled breaks on a regular basis, that would give rise to a marked limitation. Similarly, adapting or managing oneself. They've defined this as responding to workplace demands and accepting workplace changes. One of the best examples I can give from my experience is I've had clients who a new computer system is brought into their work, or new standards or items of that nature are instituted in the workplace, changing their work activity only slightly, and the person has real difficulty understanding and remembering these new requirements of their job. So what used to be rote now must be learned again. And that may give rise to supporting cognitive dysfunction for adapting or managing oneself. Understanding, remembering, or applying information is also considered. And it's at a very low level that the SSA looks for. If you can reliably carry out just a 2-step instruction, you would not have a marked limitation. But if you're unable to carry out a 2-step instruction reliably, you may have a marked limitation in cognitive function. Finally, interacting with others. Many MS patients may have some behavioral type issues due to their condition. And if you have issues accepting correction or working with others without distracting them or being distracted yourself, that may give rise to a cognitive marked issue. Working with others can also include distractibility. If you have such issues maintaining focus that having another person around you talking or working on a task would break your focus on a regular basis, may give rise to a marked cognitive limitation. So that's what you're looking at as far as this second MS listing. Marked limitations in physical issues, as we talked about a moment ago, and in cognitive function, as noted on the screen here. There are several other listings we can look at for multiple sclerosis as well. If I could get the next slide. What we have before us here are 3 alternative listings that may apply to MS for specific MS-based symptoms that many patients have. These are not specifically addressed in the generic MS listing. They're kind of alternative paths to take if your symptoms support these. They may look at visual dysfunction, and it's a fairly difficult standard. They want visual acuity of below 20/200 with glasses, or a visual field limitation of below 20 degrees, and that's kind of how wide your perception may be. It's a fairly difficult standard, but for some patients with severe optic neuritis or visual issues, they may look at that standard. You need to remember, though, that these issues have to last for at least 12 months. So if your optic neuritis comes and goes in the course of a week or 2 or less, it would not be applicable. This has to last or expected to be last for at least a year. Listing 12.02 in some scenarios may also be applied, and it looks at neurocognitive disorders. And there's a lot of language there below that outlines the listing itself. But essentially, they're looking for a significant decline in complex attention, executive function, learning and memory, or social cognition. Plus, an extreme limitation of 1 or a marked limitation of 2 of the cognitive limits we talked about in the prior slide, or a condition that's so severe that it requires at least 2 years of support in highly structured settings due to a person's issues with adapting to work changes or life's demands. Essentially, this listing looks at you have an extreme decline in your mental abilities that requires you to have significant cognitive limitations, or your condition requires you to be, to an extent, institutionalized or placed in a very sympathetic setting to function properly. It is a difficult standard, but it may apply in some scenarios. Finally, the SSA does over time take greater and greater notice that there are behavioral and emotional complications that can arise from MS and from the changes a person goes through with MS. Listing 12.04 addresses some of those, specifically looking at depressive, bipolar, and related conditions. And if you're able to show that medical documentation of numerous severe symptoms of depressive disorder or bipolar disorder exists, again, that's medical documentation, good evidence of what's going on, and that there's extreme limitation of or marked limitation of 2 of the cognitive limits in the prior slide, or alternatively, that your condition is so severe that it requires 2 years of being in a highly structured setting, those types of emotional issues may also qualify you. Again, this is a rather difficult standard that shows significant dysfunction from behavioral issues or a requirement to be institutionalized to an extent. But it is an avenue out there when MS does cause dramatic symptoms. Many clients will not be looking at these 3 listings, but we just wanted to point out that they are there at the present time. If I get the next slide. Thank you.
Did you want to add anything in, Roz, before we go to the polling question?
Well, I just wanted to thank Jamie for that very clear and detailed explanation. That's a lot to think about, and we don't expect you to remember all of that. So we're going to give you some tips and tools to help. But first, let's do our polling question number 2. Have you talked with your healthcare providers about planning for your disability application? Yes or no? Okay, so more than half of you have not, but a good chunk of you have started this conversation with your healthcare providers. We'll go on to the next slide. So one of the reasons that we ask this question is that planning and preparation for a disability application needs to begin well in advance. You and your healthcare providers need to have your ducks in a row in order to be able to fulfill the requirements that Jamie has described so well. And one of the changes that's happened with the new listings is that SSA is now encouraging, inviting input from other healthcare providers beside your neurologist. Your neurologist is important, but SSA recognizes that people often actually spend more time with some of the other providers they may see. For example, a physical therapist who works with you on a regular basis, or a neuropsychologist who's worked with you on cognitive function. So the neurologist's input is important, but so is the input from these other people. That means that as soon as you or one or more of your providers thinks that you may start running into difficulty being able to perform in the workplace, you need to have a conversation about it and begin to plan. So you want to talk with your providers about your limitations well before you're deciding to leave the workforce. The SSA wants to see evidence by your own reported your difficulties and your healthcare providers' tracking of your changes over time that you have worked through some limitations, but that your limitations have increased over time. So if possible, start these conversations early, but also review your most important treatment records with your healthcare providers for any errors or omissions about what has gone on with your condition. When you apply, SSA is going to go to your healthcare providers, the ones that you choose, and you or your attorney should obtain from those healthcare providers statements of your limitations. So the doctor or your other healthcare provider is going to provide information that is going to support your application. Next slide, please. So the National MS Society has created a new guidebook. It is designed for you and your healthcare providers to support the application process. And you'll see here that it is available online at nationalmssociety.org/SSD guide. And so you can download it for yourself and a copy for your healthcare provider, but we are also giving the same information to healthcare providers so they can have access to it as well. Next slide, please. So the contents of this guidebook are quite comprehensive. So first, there's a very detailed description of the application process, step by step, what you will go through to file your application. There's also a glossary of terms because, like everything else in a government publication, there's a lot of language that may be unfamiliar or complex, and so the glossary is there to help you wade through it. There's a complete listing of impairments, as you've heard already, for multiple sclerosis. There is a disability evaluation checklist for healthcare professionals. So the healthcare professional can track the progress of your disability using the actual language that's in the law and the numbers that Jamie referred to when he described the MS listing. In addition to that, there are worksheets for your personal use so that you can track your medical history. You can describe how MS symptoms impact your functioning and ability to work, your prior work history, and any supporting information from other people, family members, friends, or neighbors who have additional information to provide. And lastly, there's a section on how to get assistance with your application. And I just want to show you a few sample pages so you'll see the level of detail that the guidebook offers. Next slide, please. So this, for example, is for your healthcare provider. And this is a checklist about physical functioning. So when the neurologist, for example, does a neurologic exam, he can or she can document exactly what the physical symptoms are when the neurologic exam was done and what tests were done to come up with the findings. Next slide, please. This is another sample page that a healthcare provider might use on the neurocognitive disorders that Jamie described. Again, with evaluation dates and test results so that the healthcare provider is literally documenting, according to law, the kinds of symptoms that you are also reporting when you talk about your difficulties at work. Next slide, please. And here's one on mood changes, which we know are very, very common in MS. And this is an opportunity for the physician or the mental health professional who's working with you to indicate exactly what kinds of mood changes you may be experiencing. Next slide, please. And these are the worksheets that are made available for you to actually write in your guidebook and then share with your healthcare provider so you can gather the medical information you need to complete your application. You have a worksheet to describe how MS impacts your functioning and your ability to work, a place to track your work history, and finally a sheet to get that supporting information from family, friends, and colleagues. And ideally, the information that you're providing about yourself aligns with the information that your healthcare providers are providing from their viewpoint. Next slide, please. So we have one last polling question. Have you worked with or consulted with a disability attorney? Yes or no? %26 of you have, and 74% have not at this time consulted with an attorney. So now I want to turn this back over to Jamie to talk about what the role of an attorney might be and how the attorney might be able to help you at different points in the application process.
Thank you, Roz. And the different worksheets, and especially the guide that Roz talked about a moment ago, and that she and the MS Society were kind enough to create on behalf of the MS community, is a very, very good start to help you get your feet on the ground and understand the process, and to get some hints and tips as how to be your own best advocate in the disability process. Even at that, however, we find, and with biases being noted here, we find that many times attorneys do provide real value in claims such as these. As you've heard so far today, there's a lot of ins and outs on these claims that can be problematic if you don't know where things are going and what the SSA is getting at. So we're often asked by potential clients, by organizations we work with, when an attorney is actually needed. We recommend an attorney even at the initial filing. And we do in part because oftentimes the biggest mistakes are made on day one. And if you have an attorney guiding you from the very start, it can make for a smoother process. The initial filing is the quickest way to get approved as well, and doing it on your own at that stage may cause long delays over the appeal process. However, with that being said, some individuals do the initial filing on their own. Some do have success with it. We find that the selection of attorney often assists a person with comfort as they go through the process there. And it may also just go for simplicity and allowing better coordination. But a person who files on their own at the initial level is by no means making a mistake. It's just a different choice they're making at that stage. That being said, if a person does choose to file on their own at the initial level and is denied, in my view, it's absolutely necessary to have an attorney for either the appeal on reconsideration or the hearing level. At that stage, in my view, you've taken your shot to get it approved without getting counsel involved. And at this point, it's really your last chance to have counsel correct any errors that may have been made and to add additional information to your claim, to coordinate better with your doctors and really polish things up as best as can be. So long story short, we recommend you have an attorney at your initial filing, and we believe it's necessary to have one for the appeal or the hearing. Many folks who call will ask us, what do attorneys charge in these cases? And we're sympathetic of the horror stories that have been heard out there about what attorneys charge in different cases. The fees set in these types of claims are universal. They are set by statute by Social Security. They are contingent fees, and that's a fancy way of saying we only get paid if your case is approved. So there's no retainer paid up front. There's no check at the initial meeting or anything like that. We're paid only if and when your claim is approved. And attorney's fees are based upon the past due benefits. Because these claims do take a period of time to be resolved, once you're approved in the vast majority of cases, Social Security will owe you money to bring you up to date as far as your benefits goes. The attorney's fee is generally based upon that initial past due benefit and is capped at no more than $6,000. So even if your case goes to the full appeal stage and has to go before a judge and takes a couple of years of work and effort by your attorney, we're capped at a fee of about $6,000 on this case. My clients, I believe, do generally find that the fees are fairly reasonable in claims like this. We do recommend that if you do speak to an attorney, you ask not just about the attorney's fee, but also ask about the costs on your file. There are attorneys out there who will charge you for every page they copy, every stamp they send out, for mileage, for postage, for various expenses. These may or may not be legitimate cost or standard fees that attorneys charge. You certainly want to make sure you're aware of it. We find that many firms out there will waive most of the expenses except for the expense of medical records. And in fact, in some states, medical records are obtained free of charge by statute. But when you do speak with an attorney and talk about what you're going to be paying at the end of the day, you want to ask about the fee and you want to ask about the costs on your file as well. And both of those should be clearly outlined in any fee agreement that you look at. If I was advising a friend of mine as far as attorneys go and what they should look at in their attorney or look for in their attorney, one is, what is that attorney's experience with multiple sclerosis claims? Your claims as an MS patient are fairly unique as far as the claims disability attorneys see. Many disability attorneys have practices primarily focused on orthopedic claims, knee injuries, back injuries. Your claim is somewhat different than those claims and has to be approached differently. So this attorney should have experience with those claims and know what the medications are, what the symptoms are, be able to have some kind of knowledge of MS. They should also, in my view, have a practice focused primarily on disability claims. This statute is sufficiently sophisticated to where you really want to know all the ins and outs and have experience with the law, with the judges, so you know exactly where to take a case when it comes in. You also want to make sure that your attorney is reachable. If you call the office, do you actually get a hold of the attorney? Are you sent between attorneys? Are you only speaking with the assistant? These are things that at points of crisis or time crunches will be important to you. And finally, I would look for actually knowing what attorney will handle your claim at the time of the hearing. In my experience, these are some of the most important factors there. You may find others, I'm sure there are, but those are four that come to mind for me. Next slide, please. So we've talked about a lot of information today. We've talked about the wonderful guidebook that Roz and the MS Society have created to give you background on how to go ahead and apply for disability and how the program works. We've also gone in some depth on the different guidelines for disability and the different standards you'll be held to in applying for disability. Those standards essentially come down to 3 different tests, and qualifying under any of those 3 tests will get you qualified for disability. As you may recall, we look at that 2-part test based upon whether you can do your work in the past 15 years and sedentary work for a person under age 50 or light duty work for a person over age 50. Alternatively, you can show qualification for disability by meeting the MS listing, discussing extreme physical limitations, limitations of use of 2 limbs so dramatic you have issues standing for even a brief period, raising from a chair for a brief period, or doing basic activities with your hands. Alternatively, and the third way of getting approved is by showing marked physical and marked cognitive limitations due to your multiple sclerosis. Again, issues with standing and things of that nature that are marked in their limitations. Showing any of these 3 tests will get you qualified for disability. If I get the next slide, please. We also recommend that you be aware of how long the timeline can be for a decision. The fact that you're listening to this webinar now should mean you're planning ahead as far as how to go about this process. You want to keep in mind it takes a long time. Even the initial decision will typically take 3 to 5 months for that first decision. Many people, especially those under age 50, will have to appeal that initial decision. In most states, that is reconsideration, where they look at your file once again, and reconsideration is generally an additional 3 months, possibly more, possibly less. Most people will get denied on reconsideration, and if that were to occur, you would have to request a hearing. And that can take an additional 15 to 24 months from request for hearing to when one actually occurs. It could easily be a 2-year or longer process from application to decision. You certainly want to keep that in mind when you're applying, and make sure you have the financial and emotional wherewithal to go through that process, and also prepare those around you as well for what you're going to be going through. Regardless, we wish you the best of luck going forward with this process and with your claim moving forward. And Roz, it's my understanding you have some additional resources to share with these people as well.
We do, but the first bullet on here is actually Jamie's firm, www.jrhlegal.com, and so he's kindly said that there's information available on his website to help you with these timelines and requirements. There's also information available from the National MS Society, and if you have questions that we don't have time to answer tonight, you can call the number here at the National MS Society and speak to one of our MS navigators who is trained to answer questions for you about Social Security disability. And the Social Security Administration itself has a helpful website and a number that you can call, but you may have to wait a little bit of time to get an answer. So any of those resources are valuable. And in the guidebook, which I hope you'll all download and get familiar with, there are lots of resources also listed in the guidebook. So good luck from me as well. And I think we're ready for questions.
Thank you so much, Jamie and Roz. I appreciate all that information. We did get a number of questions from folks who already have SSDI. Now, can they possibly take, with these new requirements, can they take their Social Security disability away from them? That was a big concern. Jamie, could you field that one?
Yeah, and it should be a major concern for people who have disability benefits. And there's really a two-part answer to that question. So part one is Social Security reviews disability claims every 2 to 7 years. And in my experience, and half my clientele are MS patients, we find that it's very rare to have an MS patient have a negative experience on review. The SSA focuses on, does your condition still exist? Is it still symptomatic? Are you still treating? If you check those boxes, generally, you'll be okay in the review process. However, the specific test the SSA will look at is the test you were approved for disability under. So for people approved prior to fall 2016, the old test will still apply. The test we've discussed today applies only to those people from fall of 2016 forward. So the older folks are grandfathered in, and this would not impact them upon review.
Can I add, or one of our participants asked, once approved, how do they determine how much a patient gets per month?
And the amount you get from disability, there are floors and there are caps to those benefits. And the cap, I believe, is about $2,600 per month, but it's based upon your lifetime earnings. And an example I can give is if you're, say, 64 years of age, they may take your highest 30 years of earnings, run it through a rubric, it produces a number of the monthly benefit. If you're 40 years of age, they may take your highest 15 years of income, run it through that rubric. So depending on how old you are, they'll take your highest year's incomes and you run that through the calculation. They don't take your most recent work. They take your highest years of earnings in your lifetime, and that's how they calculate it. Most people we find get about $1,200 to $1,800 per month, something in that range.
Great, thank you so much. You know, a simple question, and this was one of our participants asked about some of the acronyms we have been using. So can you just give us a quick definition of SSI versus SSDI?
Yeah, we touched on it briefly earlier, but I'll go in a bit more depth now. SSDI is the program most of us think about when we think of disability. and it's Social Security Disability Insurance. It's for folks with a solid work history, and it pays out a higher benefit amount. As I mentioned earlier, $1,200 to $1,800 per month for most people. It also has some important side benefits to it. It does allow for a benefit to be paid on behalf of minor children, which is up to 1/2 of the individual's benefit. And it also allows you to work part-time. You can make up to about $800 per month without it impacting your benefit. It also gives you access to Medicare, which is a huge benefit for the MS community. But there's a 29-month waiting period from when you leave work to when you can qualify for Medicare. SSI, on the other hand, is a much more bare-bones program. It does not take work history into account. In many states, it pays about $700 per month. But it takes away dollars if you earn above, I believe, $20 in a given month, or if you're getting support from those around you. It also gives access only to Medicaid, which is a much lesser health insurance program. So you have SSDI, which is the good program, based upon work history, gives you access to Medicare, gives you benefit for your children if they're minors, and also gives you allowance to work part-time. Or you have SSI, which is a lower income program, lower asset program that pays you less and gives you access to Medicaid instead.
Great, thank you so much. So I have a question about somebody who was on disability, and then they actually decided to return to work. They realized that the returning to work was not serving them, and decided that they wanted to go back onto disability. Are they still eligible? Do they have to reapply? How does that work?
Yeah, so the Social Security system is built as a bridge program. They really want individuals who go out on SSDI to return to work and make it back in the workforce. So Social Security has built multiple steps to get you from disability to go back to work that allows you to fall back into disability again if need be. So once you're approved for disability, you can work part-time. And there are limitations, and you want to talk to an attorney before you do it. But generally speaking, if you're working part-time, if you're making below $800 per month, it wouldn't really impact your disability benefit. If you work and you go back full-time, or you make substantially more than $800 per month, they would reduce or cut off your disability benefit as you go back to work. You can attempt that return to work for approximately 9 months. And the SSA will stop your benefit for that 9-month period. But if within that 9 months you decide, my condition's worse, I'm not improving, I'm not comfortable with this job, I really can't handle it at this point, and if you fall out of that job within 9 months, you can call Social Security, and you can generally go straight back on Social Security disability. And it's as simple as that. If you do that position for 10 months or longer, you are treated as a brand new applicant in the disability process. However, we find that many judges who see a person go back to work after an approval look at them sympathetically, give them a little bit of credibility for having attempted to go back to work, and the process on reapplication may be a bit simpler, but there's no statutory requirement that they do so. So long story short, you can go back and work part-time and stay on disability. If you go back full-time and you do it for 9 months or less, you can typically jump right back on disability. Or if you do it more than 9 months, you have to reapply. In any of these scenarios, you should be speaking to your attorney before you go back to work to just have it dummy checked. And you should let Social Security know when you go back to work so they can modify your benefits accordingly. You do not want to have the SSA paying you too much, because they will discover that overpayment eventually and request reimbursement.
Terrific. So a couple of people asked about long-term disability that is received from their employer. How does that interact with Social Security disability from the SSA?
Yeah, so it's a totally separate and distinct program with totally separate and distinct requirements and payments and things like that. But there's a couple of general hints and tips you want to know as far as long-term disability is concerned. One, long-term disability initially will typically look at your own occupation, just the kind of work you were doing before you became disabled. And typically that's all they'll consider for approximately 2 years after you go out of work. For most of those LTD policies, after 2 years, they'll look at any occupation that pays a similar amount to what you were making before. So there's a bit of wage protection on that. The big catch is, whatever the amount long-term disability will be paying, they take what's called an offset if Social Security disability is approved. And by that I mean if long-term disability is paying you $3,000 a month and Social Security then pays you $2,000 a month, you're not going to get $5,000 a month. You would then get $1,000 a month from long-term disability and $2,000 a month from Social Security, because long-term disability just makes up the difference there. Earlier we talked about attorneys and the value of attorneys. If a person's ever denied long-term disability benefits, it is imperative they get an attorney immediately. Those claims are much too complex to attempt on your own, and an attorney's ability to put things back together after they've been denied is very difficult unless prompt notice is given. So it is a wonderful set of programs to have, and it is a tremendous fallback financially for your family. And if an MS patient has a long-term disability policy, that should be the first bill they're paying each month. It's that important. But you got to be very careful with it.
Gotcha. So here's a real-life scenario, and I think I might know the answer to this, but one of our participants said that they applied for Social Security disability about 3.5 years ago, and they've been denied 3 times. She can't work. Her job forced her to medically retire 4 years ago. Her MS specialist says that that she cannot go back to work. She's very stressed and having financial difficulties. She doesn't know what else to do. What do you recommend?
So one of the things many people don't know is that there is a sunset provision on your disability application. And if I work consistently and I leave work today on a disability, I can apply for disability over and over again for 5 years. So the person you mentioned who left work 4 years ago can and should apply once again. Because as long as she shows she's disabled within 5 years and applies within 5 years in that application, she may still qualify for disability benefits. It is possible that person has had a difficult adjudicator on their claim, has done it without assistance or without showing the proper evidence in their claim, and a new bite at the apple may be of assistance there. We mentioned earlier the concept that you have to have both lifetime work history and recent work history. This is where that recent work history comes into play. 5 of the previous 10 years you have to have worked. So if she's been out of work for 4 years at this point, she'd have 1 more year of application to go. So that person certainly should look at a new application. If she's been denied previously, there are certain periods where you can file an appeal of that prior denial. She should be considering that as well. And again, that is where having counsel is really beneficial, to walk you through the guidelines and let you know for her specific condition and symptoms whether or not further applications are appropriate. But it sounds like there's an opportunity, but time is running very short for her.
Okay. One thing that you mentioned, Jamie, in your presentation was the alternative listings for MS. And so one of our participants mentioned that they have severe double vision. And how would that play in with the visual dysfunctional listing?
Yeah, so the listing itself, they probably wouldn't qualify for. However, remember, we talked about several tests today. And one of the tests is that generic 2-part test of can they do their past work in the past 15 years, and can they do alternative work based on their age. If a person has severe double vision that is consistent, it's likely they can't do their past work in the past 15 years. And it's also likely they couldn't do alternative employment. So you don't want to focus solely upon the listings in this kind of claim and this kind of condition. You want to look at all your different tools in the tool chest there. And one of those tools is that generic 2-part test And if I have a person call me who has just tunnel vision, I can knock out a lot of jobs with that kind of issue. And that's how I'd approach that claim. If you add on top of that other common MS limitations such as fatigue, such as exacerbations that knock you out of work periodically, that may give rise to a claim. But you've got to approach it just right. And if tunnel vision is the primary part of the claim, that person may be denied initially and may have to go in front of a judge to make a more sophisticated argument at that level.
And Jamie, what if the symptoms are intermittent and they only happen a couple of times of a month? Do they still qualify?
It depends on the symptoms and how intermittent is. So one of the things judges will do at most hearings is they'll have a vocational expert there, a person there to talk solely about jobs and how the national economy works. And one of the fun things that we get to do as attorneys in these claims is question the vocational expert and pick their brains about how the economy works. One of the things that we oftentimes will ask that person is with what frequency a person can be absent from work and still be employable. And the general answer is somewhere around 2 to 3 days per month. If they're absent, a person becomes unemployable. So if intermittent means they can't go into work 3 days a month, many vocational experts will say that person's not employable. The catch in those claims is you have to have pretty good evidence to support that it's actually 2 or 3 days a month. You have to have notations from your neurologist consistently there's that issue, notations preferably from a primary care as well, possibly even a note from your prior employer that you were using sick days on a regular basis before you ran out of them and left your position. You've really got to work to prove that evidence to show the judge, Your Honor, I'm not just saying this, there's solid significant evidence that I can't show up 2 or 3 days a month. You use that evidence plus the vocational expert's testimony, that's how you can win that claim.
Thanks, Jamie. Roz, I have a question for you. You talked about the checklist and what to ask your doctor. What if, in reality, your doctor has not been writing down all the things that are discussed at an appointment? Do you have any suggestions for how to more effectively work with your healthcare team?
It's an excellent question, and unfortunately, I think that happens more often than we would like to think. So one of the reasons we encourage all of you to start planning for a disability application well ahead of time and forming that partnership with your healthcare providers is the best way to avoid that problem. Once that problem exists, I think you have to work with your doctor and then spend sufficient time documenting a decline in your ability to perform or to show that your condition has worsened, because they really want to hear from healthcare providers in what ways your MS has progressed and your symptoms have worsened in ways that interfere with work. So the best way to address that is to prevent the problem in the first place, but then you may have to play some catch up. Jamie, do you agree with that or have anything you want to add to what I just said?
I do, and so Roz, the advice you give is good. I'd add to that if you're listening to this podcast or this webinar we have today, next time you see a neurologist, ask for an extra 90 seconds. That's all it's going to take from the neurologist or the nurse or whoever takes the background on your condition and say, I just want to run through all my symptoms. And you'll ignore the little ones on a regular visit, but go through all of them and just take 90 seconds and touch on everything, work from your head down to your toes. Make sure they all get on the record at that point. Because the toughest thing I see is when a client comes into my office and has a good claim and I get the neurologist records and they just don't have good documentation. Because over the years you haven't thought to talk about what you ignore. So the next time you go to see your neurologist or one of your docs, just ask for 90 seconds and run through those conditions head to toe. It's the best way to make sure everything gets on the record and everything gets documented. Also asking for a copy of your medical record. We find with the electronic medical records that have become so prevalent, they're wonderful because we can read them, but things oftentimes get left out or forgotten on those. Just taking a quick look through your record may be helpful as well.
Just to add one more thing to that, the appendices in this guide that give you worksheets to track your symptoms and how they impact your ability to work, that's important information for you to share with your provider. And you can share it at every visit, particularly if your condition is worsening. So as you talk about the symptoms that are getting in the way of your performance, that's something that the doctor can put into the medical record at the time of each visit. So over time, you're tracking exactly what's going on.
Terrific. You know, I had a couple of questions about being denied and how long you have to wait before you can refile. Is there a waiting period?
There's not a waiting period per se. Initially, when you're denied, your first thought should always be filing an appeal, because if it's worth filing an application, it's worth appealing. Generally, I believe that's the case up until you get to the administrative law judge. Appealing the administrative law judge can be more problematic. If you're denied by the administrative law judge, generally the SSA suggests you wait about 65 days until you file a new application. My rule of thumb is you should really go to see your doctor again after that judge issues their decision, and especially if there's any change to your condition for the worse, let your doctor know about that. And what that would allow you to do is, in your new application, you can say, Judge so-and-so may have been right in denying me previously, but now I have those allegations, plus I've gotten worse in this way or that way. That can be a nice benefit moving forward and showing the court they may have been right in the past, but the game has changed to an extent now. So your best rule of thumb is you really can't reapply for 65 days, and you really typically want to go see your doctor again after the denial comes through and discuss any increase in your symptoms at that time and make a new application with those additional allegations at that time.
Great. How about a person who is self-employed? Do they have access to SSDI?
Yes, and I can say firsthand that us self-employed folks, we do pay the same taxes everyone else does, and then some oftentimes. So you will pay Social Security income tax on your earnings as a self-employed individual, and those taxes go into the program just like any other workers does. So that'd be factored in. It's a bit more complex for that worker if they continue to work part-time during the application process, because while a worker at, say, a grocery store simply shows us their W-2s for their income, a self-employed person is showing income and costs, and you have to calculate what the actual income may be. So it's much more challenging to figure out whether or not they're above the thresholds for part-time work, but it's doable. And certainly self-employed folks do have access to Social Security, and many of those folks do not have access to long-term disability. So it's their main avenue there, but they should certainly be looking at it because they have paid the taxes required to qualify.
Great. What if someone wants to go back to school? Would that affect their SSDI?
So I'm not aware of a specific statutory provision saying there are issues there. My rule of thumb is that if you're going back to school full-time, a reasonable judge could compare that to going back to work full-time. So I typically recommend my clients who look at going back to school, do it part-time. And in all honesty, if you're applying for disability, generally a full-time course load is going to be well beyond your physical capabilities. If you're going back for 6 hours per semester, that's typically consistent with part-time employment. I don't have an issue with my clients doing that, and I'm able to properly explain that to a judge. Many of those individuals are able to show the judge the work ethic required, the different steps they have to take to conserve their energy when they're going back to school, different accommodations they're given in school. We can actually change that additional activity into a positive for their claim that actually positively reflects upon their work ethic and upon their attempts to get back to work. So I by no means discourage that, and presented properly, if you're going back part-time, may actually benefit your claim.
Great. I did get a couple of questions about people that might be interested in seeking attorneys. Is there a central resource on the internet that that might be a good place for them to go? And the second part of that question is, Jamie, can you talk about what states that you serve through your practice?
Yeah, so I'll answer those, both of those in turn here. My office, and again, we're here to provide you folks with information, not to sell a service, just to be clear. I do cases nationwide. I'm based out of Pennsylvania. I had an approval earlier today out of California. So we do them nationwide if a claim is good and if it has validity, and probably about half of our clientele are MS patients. If I'm looking for an attorney, again, we went through some of the factors we would look at earlier in the webinar, but if I'm looking for a clearinghouse of attorneys, you may be able to get quality counsel through your county bar association. They may have a referral service there. There's also an organization of disability attorneys called NOSSCR, NOSSCR.org. You may be able to look there as well. And again, as I said a moment ago, we also assist folks nationwide. They're welcome to give me a call with questions or issues or simply advisement there. But there's a couple ways to go. What you don't want to do is just go to Google and type in disability attorney. You want to find it from a referral source, again, whether it's what I mentioned earlier, possibly even your neurologist may know of an attorney who can work with you, but you want to get them referred and confirm that they are knowledgeable what they do and that they work with the MS community and that they work with disability on a regular basis.
Great. You know, oftentimes with these webinars, you know, questions always go back to the healthcare team. So Roz, I'm going to ask you on one of our participants just said that her physician suggested that she should go back to work because she might be more depressed if she doesn't work. How would you respond to that?
Well, without knowing the person and what the doctor's experience is with that person, I think the decision about whether the individual with MS is able to work should be based on the criteria that Jamie described. Certainly, sometimes people leave work because they're feeling stressed by it or overwhelmed by it, or they're feeling very depressed about work, and then finding themselves without work can only add to their stress or their feelings of depression. So I think that the doctor is saying that out of concern for the patient and worrying that he or she might experience greater depression at finding herself unemployed. But I think they're two separate questions. And I think what that individual needs to do is talk to the neurologist about the criteria that Jamie outlined so clearly here. Is the person able to work or not? And then just get help for their mood issues with a mental health professional apart from that application.
And I would add to that briefly that some doctors out there don't appear to believe in disability as a concept. If a doctor is directing you to go back to work and you think it's not appropriate, ask why they believe that's the case. Try to find out where the disconnect is at. And if there's a disconnect where the doctor's not recognizing your conditions, you need to figure out whether you're not listening properly, they're not listening properly, whether a new doctor is appropriate, and you want to try to resolve that issue. Because again, there are some doctors who we find don't tend to believe in disability as a concept, and you want to find out if it's that kind of scenario or if a person's just overestimating their own limitations. And it's a very important distinction to make as early as possible.
Great. We have time for one final question. And the question is regarding disclosure. So one of our participants noted that they have not disclosed their diagnosis, but they're noticing an increase in issues. Should she consider disclosing now, thinking about a disability claim down the road?
So she should think about it. There's 8,000 reasons on one side and 8,000 reasons on the other side. She should be thinking about it. She should be reaching out to people who know what's going on as far as what disclosure means. As that person, I'm sure, has thought about many, many times, there's a positive impact in that if you're of a proper employer size, you'll get certain protections under the ADA. There's also negative sides, where some employers will not play by the rules for a person who has a disabling condition. There's a lot of factors to think about there, but you want to think about disclosure early, and you want to make a reasoned decision based upon good information obtained from experts. And that is a very individualized basis. And I commend the person for thinking ahead about how to answer that question.
And I would encourage the person to speak to one of the MS navigators at the National MS Society and talk through that whole disclosure decision. There's also a good tool on the National MS Society website to help you think through disclosure decisions. But in general, if you're going to disclose, it's really important to disclose in a way that says, I'm disclosing my disability because I need an accommodation in order to be the most effective employee that I can be for you, and to suggest at the same time that you disclose what that reasonable accommodation might be, because then you're not only disclosing, but you're committing yourself to working as long as you can, being the best possible employee that you can be.
Thank you so much, both Jamie and Roz. I think that was a tremendous amount of information. And just a couple of things before we finish up tonight. We do have a number of resources that you may find informative and helpful. On the CanDo MS website, mscando.org, you'll find archived webinars, e-news, and library articles. And you can also submit a question to the Ask the CanDo team, which will be answered by our team of MS experts. The National MS Society also has a number of resources. And as we mentioned, the guidebook on Social Security disability is going to be available via a link in the follow-up email that we send out this evening. And they also have a variety of video segments that can be accessed on their website as well, nationalmssociety.org. The next presentation in our webinar and telelearning series will be on Tuesday, November 14th at the same time. It's going to be the sandwich generation, caring for yourself while caring for others. As always, you can register for free of charge on the CanDo MS website, mscando.org. And if you would like to help support our webinars by texting to donate, you can do that by dialing 970-626-6232. And one final note, I would ask that you complete the survey that pops up on your screen at the conclusion of the webinar. Thank you so much for joining us tonight. Thanks again, Jamie and Roz. I appreciate all the information that you've provided, and have a great evening, everyone, and take care.